And even if we don't have a liquidated damages clause, and I come to you and I say, you committed a breach, I estimate that my damages is 1 million, give me 1 million, you give me 1 million.
So have you ever been in a contract where someone breaks the deal? What happens next? And we have something called the liquidated damages, which we're going to talk about today with Kat, our business lawyer. And also in this case, be very careful what you sign in terms to the liquidated damages. And we're also going to have Kat explain this to us so we know what to do and not to do when it comes to liquidated damages. Stick around because this is very important information, knowledge sharing, not legal advice as usual. Welcome.
Yeah.
Let's start.
Let's go.
And this is also powered with LE Fitness. We're very happy to share that.
Oh, indeed. Okay, because this is a really, really dangerous clause and a really smart clause if you use it rightly and depending which side you are on. So typically, if you commit a breach against the contract you and I have entered into,
yes,
I need to prove the damage in order to get damage, money from you, whatever damage I suffered, right?
Yes.
But that can be a really hard thing to do.
Yeah, depending on, do you have to have good proof?
Yeah, and that can be really hard, in particular if I feel like I lost out on profits and so forth. So we can instead use the liquidated damages. Then we predetermine what you should pay me in certain breaches. So imagine that you deliver fruit.
I deliver fruit every day.
And I order strawberries from you. I'm going to have this big pitch event from huge VCs. I'm in Silicon Valley. I'm flying in. It's huge. And I order fruit from you, the strawberries. They're supposed to come at 9 o'clock in the morning. They don't come. You do not show up. Or even worse, they do come, but there is some salmonella in them.
Oh dear.
So all of the VCs who have eaten from them end up sick, and then they affiliated with me, so I don't get any capital. It's a mayhem, it's a catastrophe, right?
Sorry.
Yeah. So regularly I have to kind of prove what damage did I suffer. And that can be really hard because I have to prove that, number one, they got sick from your fruit. Number two, that they got sick meant that they kind of hate me because I'm the one pulling them all together. I'm responsible. I'm the one treating them to the fruit, to the strawberries. And that meant that I lost out on my investment and my company went bankrupt. You can tell how many things I have to prove to try to get all of those millions that I want.
It could be a catastrophe, as you explained.
Yeah. In my head, it's obvious. It's all because of the strawberries. But in your head, it's like something happened. They might have been ill for a day or two. But it's not my fault that they didn't want to invest. You did your pitch. They just didn't like you, right? So we end up in a dispute. We go to court, and I try to claim damages, and you say, well, no way. Or it might just have been the case that I had to run across the street and buy more expensive strawberries from somebody else because you didn't show up. Well, then the damages is the replacement cost. So you can tell it's a complex situation determining what the damages are and where in the chain to stop. How much is where's the reasonable relationship between the damage you caused and the damage I claim that I suffered due to your breach of contract.
Okay.
But if we have a liquidated damages, we might just predetermine what you're going to pay me. So we say that, okay, in case you do not show up, you pay me 10K. It's a big event, many strawberries. So you need to pay me 10K. Well, then if you don't show up, you pay me 10K.
Oh, this already decided.
Predetermined. We don't have to negotiate or dispute over what damages did actually occur. Or we can say that, okay, if your fruit is not viable, if somebody turns in and we can prove that it comes from your fruit, you need to pay me 100K. Again, we don't have to prove what actual damage happened. Then it's just straight, yes or no, it's binary. Did the breach happen, then you pay me this amount.
Okay, so this is like instead of going to court.
No, and that's a misconception that people have. That's completely wrong.
Okay.
Yeah, because regardless of whether you have liquidated damages or not, you can still go to court and dispute whether you owe me anything. Was there a breach at all? Did I deliver? Did I perform as I should? Or was it your fault? Nothing wrong at all? So, I mean, say it's a confidentiality clause. Did you really breach it or not? A non-compete. What was a non-competing business? I think you broke it, but you committed a breach, but you don't. So we can still end up in court, but we do not have to prove the actual damages, so it can be less costly. And even if we don't have a liquidated damages clause, and I turn to you and I say, you committed a breach, I estimate that my damages is 1 million, give me 1 million, you give me 1 million. We don't have to go to court. So that's not dependent on the liquidated damages. That's complete wrong if you hear that on the internet, which I've seen. That's a misconception. It's only about the proof of the damages.
It's really good you clear that out.
Yeah. And there is problems, as always, with the liquidated damages. Number one, it can be disproportionate. It's a big risk to sign it, because even if there's a tiny breach of a non-confidentiality and you see that there are no damages, somebody could claim liquidated damages if you have that. So be very, very mindful if you sign a liquidated damages and make sure it's very clear what it covers. And also, for both parties, you should know that most jurisdictions will not allow for it to be too disproportionate, too unreasonable, like a penalty. It has to be reasonable, otherwise they will not enforce it. So in the strawberry case, if I say you have liquidated damages for 50 million, it was strawberries for a couple of $100. Or say that you take an employment with me, I pay you minimum wages, but you have a liquidated damages clause if you go to a competitor of mine with 5 million. That's not proportionate, it's not reasonable. The courts would not enforce it, most likely.
So it has to be proportionate.
Yeah, and reasonable. So you cannot go, like, if you're the bigger, better, smarter, or the one that signed the contract, you cannot be too evil. And be sure it's very clear what it will cover and what it will not cover. That's also very, very important.
Yeah, because of what I hear, it seems like this is to protect both parties as well.
I would say mostly the party enforcing it on somebody else, the one who has to prove the damages otherwise. Being under liquidated damages, I mean, it can be foreseeable if you say it's the only remedy. But many contracts, at least in my jurisdiction, will say it's not the only remedy. They will say liquidated damages up to 50K if you're a consultant of mine and you commit a minor breach. But I will add in the contract, if the actual damages supersede those 50K, I'm allowed to go after you for those as well.
Okay.
That's what I would write in my jurisdiction. So that depends, is that reasonable or not? So if you're the one being subject to a liquidated damages, try to make sure that's the only remedy that the other party can use.
Thank you for clearing it up.
Of course, anytime. If you have more questions or examples, bring them.
Yeah, bring them on and we're going to answer them in another episode.
Of course.
And tell us about your companies too. We would love to hear that. And as always, this is not legal advice, this is knowledge sharing. And now you know also what liquidated damages can be and how it can be used.
Yep.
So put that in your toolbox as well.
Yes.
In your journey to keep educating yourself. Until next time, like, subscribe, and share it with your network.
Because we want to share at not a zero cost. The more input, the more likes, the more subscribers, the easier we'll get for us to just give you everything you need.
Yes. And this is also powered with LE Fitness. We're very happy to share that.
Oh, indeed. Thank you.
Thank you. And until next time, hej då.
Bye-bye.